Hi, Amy Pittman here with Pittman Law Office, and today is Trust Administration 101, right? So you have this revocable trust, your attorney's telling you to fund it, put your assets in the trust, or certain assets in the trust based on your certain situation, and then you die. Well, once you die, if you're the sole owner of that trust, now there has to be a transfer of those assets to the named beneficiaries. And how does that happen? Well, you have named a successor trustee in the trust. That successor trustee was named. They're not appointed. They don't have to take that position. So someone has to accept that role. So if you've named someone as your successor trustee, they're going to contact an attorney like us and be able to accept that position. So they sign what we call an acceptance of trust. We also file what we call a notice of trust in the county that you're a resident in. And typically we're going to file an affidavit saying there's no estate tax due, if that's the case, which again, the estate tax is going to be different for every state. But when we do that, we're starting an administration. Okay, so we don't have to go through the probate court. We don't have to go through the timing of the probate court, but we are going to still have an administration. It's not an automatic transfer. So that trustee steps in this role, similar to an executor, where they're having to marshal in the assets. They have to go and find the assets that are in the name of the trust. So it's going to be extremely helpful if you have a list of all of your assets, identifying if your trust is the owner or if your trust is the beneficiary. If there's other assets that you have that are not connected to the trust, maybe you've named people as the beneficiaries or a charity as the beneficiary, they need to know that too, because they're going to have to provide a death certificate. So once you pass away, this trust administration is going to start. Now, it can't start until the person has a death certificate. So if you have not prepaid for your funeral or cremation, burial, I would highly recommend it, because someone's going to be out of pocket to cover that expense before your trustee gets a death certificate. So we have to have a death certificate. Once they get the death certificate, that's when they can hire an attorney. That's when they can start canceling your cable, your cell phone, your credit cards. They're going to have that death certificate. Once we get that, we're also able to obtain a tax ID number, because while you're alive, your trust is in your social. So it's in my social security number while I'm alive. When I die, my social doesn't work anymore. So they're going to have to get a separate tax ID number. So you'll hear people call it an EIN or tax ID number. So once that trust becomes irrevocable, that EIN is connected to that irrevocable trust, and that trustee is now a fiduciary. So they're going to have to file a tax return just like you would file a tax return. So that tax return is going to be filed every year that the trust stays open after your death. So depending on the trust that you've set up and the beneficiary designations you've set up within your trust will determine how long that trustee is going to be in charge. But let's assume I die, and as soon as I die, my trustee steps in, they start liquidating my assets. Obviously, they're going to need to know where my list is of where I keep my assets, and then they're going to also need to cover my expenses. So I want to make sure that I have a list of what those expenses are. How do I pay my electric? How do I pay my mortgage? Credit cards, any of those things. I want to make sure I'm listing that out. Passwords, very, very important to make sure you're listing out your passwords somewhere. And then they're going to contact my beneficiaries. So they have to notify your beneficiaries. We, as the law firm that gets help, we provide them with information on how to do that and notices that they're going to have to provide to those beneficiaries. The beneficiaries have to be notified to let them know that they're a beneficiary of that trust. So once the beneficiaries are notified, the trustee is responsible for accounting for what they're doing. So what are the value of the assets at date of death? What expenses are they paying? So whether it's a full formal accounting or, keeping statements and providing statements to the beneficiaries, it's kind of up to the trustee and the beneficiaries. Who those beneficiaries are, the relationship between the trustee and the beneficiaries. But there's definitely going to be work, unless you die with no assets in your trust. But if you have a house that has to be sold, they're going to have to sell the house. They're going to have to clean it out. They're paying people to do a lot of that. They're going to have to make sure that your assets that are the bank accounts, investments, are getting, going after and liquidating or able to disperse in kind to the beneficiaries. So they're definitely going to have some type of administration when the person that owns the trust dies. Don't think you're in a trust to avoid probate that you're avoiding all the work that comes with it. The only way nothing is going to happen when you die is if you don't own anything. So if you have a house, if you have a bank account, there's going to be something that has to be done. Now, maybe I just have a bank account and done beneficiaries on it. Okay, easy. But somebody's going to need to know that you have that bank account and that you've named beneficiaries. The bank's not going to go chasing these people down. And they also will have to have your death certificate. So please be organized. Make sure you have communication with the people that you've named so they know where to go in your home to find this important information. They know how to contact your attorney. If you prearranged for your burial or cremation, they know where that information is. All of this is going to help, start that process sooner. So again, the idea with trust administration, yes, is to avoid probate, not to avoid an administration, but to avoid the probate time and cost. But there's still going to be work that has to be done. So make sure that your person that you've named as the successor trustee knows how to get in touch with your attorney. We will give them guidance if they're our clients on what they need to kind of look for in the beginning, and then we start them on that process. Whether they continue to retain us for the trust administration really determines the type of trust that it is. Is it an ongoing trust because my beneficiaries are minors, or maybe they're spendthrifts, or maybe they're on governmental assistance, or maybe it's just an outright disbursement. So the trustee sells your house, pays your bills, and makes the disbursement. But again, it depends on how long it takes to sell the house. What's going on with the house? Does it need to be repaired? So again, there's a lot more to it than I'm dead, my assets go to my kids. So definitely make sure that you are prepared for that, because you want that successor trustee to be able to step in that position with a really easy transition once they obtain your death certificate. Obviously, if you're a Florida resident and you want more information, feel free to reach out to us at Pittman Law Office. We also want to make sure that our clients identify all this information to their successor trustee, but also make sure that your trustees know how to get in touch with us. All right, hope that helps, and that's estate planning the P.I.N.K way.